All right, let's knock out chapter 6. So this, now we are talking about, basically we've moved on to the first appearance in court, or their initial appearance in court. Ultimately, we've kind of talked about rights that people have, what police can and can't do, what you do and don't have to say to the police. And so now we're moving on to a person actually having been arrested and now facing their initial court date and or charges. So preliminary hearing is not, interestingly, it comes up like as the first thing. It's not necessarily the first appearance in court, but let me explain what the preliminary hearing is. Ultimately, a preliminary hearing is, I like to describe it as a mini trial. The preliminary hearing is a hearing that takes place in front of a judge, where a judge will decide if there is enough evidence for the case to actually go forward for trial. So I'm going to use an example of a case that happened in Fresno. I remember this. There was a case a couple years ago where a local chiropractor was alleged to have sexually assaulted probably 8 or 9 patients. And he denied the charges, and his attorney basically said they don't even have enough evidence to go forward with a trial. So what they did was a preliminary hearing. The preliminary hearing actually took several days. It was a mini trial where a few of the witnesses and victims came forward and did a little bit of testimony, just enough to make the judge, give the judge an idea as to whether or not there was enough evidence to go forward. And so they did a little bit of testimony, some testimony from a few different witnesses. The judge heard the testimony and decided that yes, there was enough evidence to go forward with a trial. So ultimately, that is what a preliminary hearing does. Okay, so preliminary hearing, I call it a mini trial, and it does tie into what we're gonna talk about later, the same duties as a grand jury. Okay, grand juries. There's a little bit of confusing stuff in this chapter. Grand jury and preliminary hearing, they basically do the same thing, same purpose. And I'm going to kind of explain it a little bit further as we go along. So let me go back now. Arraignment. This is typically the actual first hearing. At your arraignment hearing, typically your charges are read. You have the right at your arraignment hearing to have the judge read the entire complaint, which is the actual paper document that's filed by the prosecutor. You have the right to have everything read to you out loud in court. Okay, so you have the right to have all those charges read to you. You have the right to enter a plea. There are some different pleas that you can enter. One of them is guilty. One of them is not guilty. I think you know what those two mean. Guilty, yes, I did it. I'm ready to accept the consequences. Guilty, no, I'm not guilty. I did not do it. Here are some more. Nolo contendere, also known as no contest. Not guilty by reason of insanity. Former jeopardy, meaning I've been charged with this crime before, you cannot do this again. Former judgment of acquittal conviction, I have already been acquitted of this. We're going to go further into this. Yeah, we are. Okay. So, at the arraignment, that's your initial hearing, first hearing, there are some motions or some issues that can be addressed early on with the courts. Sometimes people will ask to withdraw as defense counsel. Sometimes a defense attorney that might have a conflict with the case. Sometimes a judge might recuse, it should say recuse, take that L out, recuse his or herself based on a conflict of interest. So let's just say, for example, let's say the judge is the uncle to the person being charged with the crime. You think there'd be a conflict of interest there? Yes. The judge would say, I'm sorry, I can't hear this case because the defendant is my nephew. Make sense? That's typically, or I know this person well, or, for whatever reason. Maybe there'd be a reason to disqualify the prosecutor. Maybe the prosecutor is related to someone or knows somebody or something. So these are some things that could be addressed at the very first hearing. So a person could enter a guilty plea at the very first hearing. And I'm going to tell you why that's very uncommon. And I think a lot of people get really upset when they see this on the news and stuff. The Corey Muhammad case was one that was really upsetting to a lot of people. Corey Muhammad was the guy here in the city of Fresno who shot and killed, I believe, 4 people over a period of a few days. He admitted it. He was on video. There were witnesses. I mean, it was a kind of a slam dunk kind of case. And for his initial hearing, he entered a not guilty plea. And people were just furious, saying, how could he do that? How could he do that? Well, there's a lot of reasons why, but first and foremost, most of the police reports probably are not even done by the time an arraignment hearing takes place. So when you've committed a murder, you're going to have boxes and boxes and boxes of police reports. And granted, I mean, some of them had to be done in order for him to have been booked into custody. But I'm sure you don't have medical reports yet. There's so much information that's not there yet that your attorney would really be not doing their job by allowing you to enter a guilty plea at your first hearing. So when you see that happen and you get frustrated and you're like, how could they do that? The attorney is not doing their job if they're letting their client plead guilty at the initial hearing, especially in a serious case like that where they don't have all the information yet. Some people will withdraw their guilty plea and change it to a not guilty plea. This can happen. It does happen quite frequently. Not guilty. I think you know what that is. So I will plead not guilty. I did not do it. I want to go to a trial. Take me to trial. Nolo contendere, or no contest. Okay, this is kind of a hard one to describe, but let me see if I can kind of make some sense of it in normal English, how I like to explain it. So here is, I think for me, an easy way to understand it. Think O.J. Simpson. All right, O.J. Simpson was worth millions and millions of dollars. Let's say O.J. Simpson wanted to plead guilty to murdering Nicole Brown Simpson. Let's just say he wanted to. But he knew he was going to get sued for wrongful death, and he knew that would cost him millions of dollars. He knew also that if he pled guilty on the record in court, in criminal court, that the civil court would be able to use that against him. He didn't want it to be that easy for the civil courts to go after him. I'm not explaining this very well. Basically, no contest is an easier way to avoid civil suit at a later date. By not having to go on the record and actually say, yes, I killed her, he avoids having that on the record in court to be used against him in civil court later. He will say, I'm not going to say I did it. I'm going to accept responsibility for it, but I'm not going to say I did it. I hope that kind of makes sense. Another example, a lot of times if you're going to plead guilty to something, you have to, what they say, allocute, or explain what you did. This is particularly difficult for sex offenders because they're cowards a lot of times and they don't want to say on the record in court why they did what they did. They don't want to say, yes, I had sex with little Johnny for sexual gratification. So they will plead no contest instead so that they don't have to say the horrifying thing that they did. So in order to resolve the case, the judge sometimes will accept that no contest plea which basically is the same thing, same consequence as saying guilty, but without having to allocute. I hope that kind of makes sense. Not guilty by reason of insanity. This is basically a person saying, I committed the offense, but at the time the offense was committed, I was legally insane. Therefore, I was not responsible for the crime. And we're going to talk about this in depth later on in the semester. Okay, grand jury. A grand jury, their only purpose, typically, is to decide if there is enough evidence to go forward with a trial. Does that sound familiar? It should. It should sound like what we talked about with that first slide when I talked about a preliminary hearing. There are two ways to decide whether there's enough evidence to go forward. One of those ways is by way of a preliminary hearing, which is the normal way, which we probably do. Your average case in Fresno that's going through the Fresno County Superior Courts is going by way of a preliminary hearing. But a grand jury is another option. A grand jury is a group of people, cross-sections from the community. They typically will serve for a certain period of time, and they will hear some evidence and decide if there's enough evidence to go forward. If there is enough evidence to go forward, in their opinion, in a case, they will issue what is called an indictment. An indictment. If a person is indicted, they will be moving forward for trial. A grand jury is not the same thing as those little jury duty notices that you get in the mail. We're going to talk in depth about those juries as well. Not the same thing. So a grand jury does not decide if a person is guilty or innocent. A grand jury is a different type of jury that only decides if a person is going forward with for trial or not. Make sense? So the grand jury and preliminary hearing, they do the same thing. Sometimes they get called upon to do things, hear cases for public officials and things like that as well. I'm going to keep kind of moving forward with this. Purpose of the initial appearance. The person gets to hear the charges. Arraignment. More things that happen with the initial appearance. Steps in the pretrial process. You are arrested, taken into custody, booked. You have your initial appearance. At your initial appearance, typically you have the right to have the charges read to you. You typically are going to meet your attorney. You're going to enter a plea, and you're going to find out about bail. Again, this is all kind of, we already kind of talked about this. If a person enters a guilty plea at their arraignment hearing, then the next step is sentencing. But it's very uncommon. Oh, here, let's go through this one though. You have the right to have a trial and be judged by a jury of your peers. But you don't have to. You could also be judged by a judge. So if you, let's say, for example, and I'm sorry, you're probably going to get tired of hearing about sex offenders, but imagine your general population, your general jury of 12 average citizens hearing about a horrific sex offense versus a judge hearing about a horrific sex offense. Who do you think is going to be more horrified by that emotionally charged evidence? Probably the jury. So there are some times when it might benefit the defendant to have a judge hear the case as opposed to a jury. There are some really emotionally charged cases, unfortunately or fortunately, however you look at it. Judges hear this kind of horrific stuff on a daily basis. Child abuse, sex offenses, horrifically violent offenses. They see this on a daily basis, and can they become more immune to it? Probably. Can you and I, who are just, normal average people, do we hear about people, raping and molesting people on a daily basis? Hopefully not. So might we be more appalled by that than the average citizen? We might. So it could benefit people to have a judge hear their case as opposed to a jury. There are lots of different motions, and we are going to go through a bunch of these as we keep moving forward with this book. But there's a lot of steps, and these are all pre-trial. And I mentioned earlier, one of the other lectures, pre-trial just means before the trial. I love this too. They're always so vague. The time of the initial appearance, an arrested person must be taken before a magistrate, meaning a judge, without unnecessary delay. What the heck does that mean? What is unnecessary? I know, right? Typically, it's got to be about 48 hours. What is an unnecessary delay? I don't know the answer to that, but typically it's 48 hours. A complaint. Complaint is typically a document that has the charges written on it. So let's say I got arrested and the DA's office or the prosecutor is charging me with vehicle theft. That document that has the vehicle theft charges on it is called a complaint. Some people would call that an accusatory pleading. In the juvenile world, it's called a petition. So that document is called a complaint. I'm going to skip through that. Bail. Bail is another issue that, especially in California, has been kind of a hot topic. We, in California, outlawed bail, which is going to sound crazy because you're like, wait a minute, don't we still have bail? Yeah, we do. But we outlawed bail. It was supposed to go into effect in October of, I believe, 2018. But it is held up in the courts right now. But we have abolished bail in California, but there's a hold on that. So we do still have bail right now. Excessive bail shall not be required, implying that not all offenses are bailable. So I might ask you a question, something like, is bail an absolute right in all cases? Do you absolutely positively have the right to bail in every case? Think about Jeffrey Dahmer. Because your initial response is probably going to be, well, yeah, of course we have the right to bail. But then when you think about it some more, you think about like serial killers and axe murderers and rapists and stuff like that. And then you think, well, maybe not. You have the right for the judge to consider bail in every case. But the judge also has the ability to deny bail. And typically the two reasons why a judge might deny bail would be the protection of the community. Maybe this person is too dangerous, again, Jeffrey Dahmer, or the suspect is a flight risk, meaning they might not come back. So bail is something, typically it's a certain amount of money or collateral, maybe, the deed to your house, whatever, that you have to pay as a promise that you will return to court. A lot of people think that judges just randomly pull numbers out of the air for bail amounts, and that's not true. There's a scale, a chart that is used in order to determine the amount of bail. But the issue with bail, as I mentioned just a minute ago, that California we are trying to outlaw bail in California. And the reason for that is, think about how fair bail is. If a wealthy person gets arrested and a poor person gets arrested, who do you think's getting out of jail and who's not? And is that fair? I mean, clearly it's not. There's an issue with that. So, how do we fix that? I don't know. But that's kind of what the issue has been with bail for quite a while. So, what is the purpose of bail? Here it is. And can it be denied? Absolutely, positively, yes it can. So when you see that question, I think it's a true false maybe. You have the absolute right to be released on bail. No, you don't. You have the absolute right to be considered for bail. These are just some different forms of bail. Bail schedules, all that kind of stuff. Blah, blah, blah. What a lot of, certainly in California, what we're doing now is a lot of supervised release, where people are being released from the Fresno County Jail, and they're being supervised by probation pre-trial. So it's just something that's relatively new, but we simply can't hold everybody in the Fresno County Jail. It's just too full. So anyways, we typically don't do a bail on witnesses. But it has happened before, but not a whole heck of a lot in California. Here is our summary. Remember, preliminary hearing and grand jury. Those two basically serve the same purpose, and that is to decide whether there is enough evidence to go forward with a trial. Arraignment. There's basically 4 things that happen at an arraignment hearing. You're going to be appointed an attorney. You're going to have your charges read to you. You're going to enter a plea, and the issue of bail is going to be addressed. You may get bail depending on the nature of the crime. And that's it.